everyone. I'm Britenae Peirce here to talk to you about recent developments in federal law. And this is our 35th employment law seminar. And I think in 35 years, this might be the most we've ever had to cover in federal law. We'll be starting with an overview of what's going on. And you can look at this first statistic here, which is the U.S. Equal Employment Opportunity Commission, or the EEOC, has filed 143 new employment discrimination lawsuits in fiscal year 23. What's significant about that number? It is more than 50% increase in lawsuits filed from fiscal year 2022. And you can see the breakdown there. 25 are systemic lawsuits, which are things like industry-wide or reaching a broader group of people. 32 are non-systemic class lawsuits, and those are sometimes a lot of different employees at one different company, for example. And of course, there are individual lawsuits as well, and there have been 86 of those filed in fiscal year 2023. Not only has the EEOC been super active, we have had a lot of union activity that you guys have all probably seen in the news and maybe even felt yourself at your own businesses. The National Labor Relations Board has been helping unions recently, actually, with a new rule speeding up elections, taking some of the procedural steps out of these elections. This rule is going to take place in December, but it's just an example of the growing trend of union activity and union workers organizing. Now, the National Labor Relations Board, or NLRB, is not just helping union workers, it's helping non-union workers as well with a series of decisions and memoranda, which I'm going to go into a little bit later. But I think it's interesting to note that in 2023, the NLRB had its first funding increase since 2010. So maybe those things are related, but the National Labor Relations Board is certainly much more active now than it has been in recent memory. Aside from all of this, of course, overarching is the Biden administration. That administration is much more worker-friendly. It's adopting much more worker-friendly policies and really encouraging interagency cooperation to really promote employees' rights and fair competition across the board. Now, aside from that overview, there have been a number of new proposed rules, and the Federal Trade Commission has proposed one of them, banning non-competes. So this rule came out back in January 2023, and the FTC proposed a rule basically banning all non-compete agreements. I put here that they're retroactive. I think the actual language is, hey, if this takes effect, you must rescind all prior non-competes. But this means any non-competes you're currently relying on are in jeopardy. It also means any non-competes you're considering for future employees could be very problematic. So you do need to pay attention to what's happening with this FTC proposed rule. Now, the comment period has ended on this rule, but we don't have the rule finalized yet, and it may not be finalized until 2024. There were literally tens of thousands of comments that they're going through. We don't know yet how far this rule will reach. It's currently intended to apply to both employees and independent contractors, but the FTC did request comments on some alternatives, such as should there be salary thresholds? So we'll see what happens, but it's important to really pay attention and see what comes in the future on this rule. So keep an eye on that for sure. Now, National Labor Relations Board has also gotten in on the non-compete action, and that is in its May 30th, 2023 memorandum. Actually, the memorandum was issued by the Office of the General Counsel, opining that basically, offering or, supporting, maintaining, or enforcing non-compete agreements after employment violates the National Labor Relations Act because they're overbroad, chill employees' protected activities, and otherwise violate Section 7 of the NLRA. Now, there are some potential exceptions, perhaps such as ownership in a competing business, things like that. But I think what you need to take away from this is you really do need to be aware that non-competes are under significant scrutiny at the federal level, certainly at the state level in some regards as well. I know here in Washington, we've got our own non-compete laws and rules that you have to be aware of, but someday soon those non-competes could be gone altogether. Also, before I turn to our next proposed rule, just as some background that may be helpful for employers to be aware of, the FTC and the NLRB back in 2022, they entered into a memorandum of understanding, essentially saying, hey, we're going to work together. We're going to go after collusive behavior, restrictive covenants, things that are hurting our workers in the United States of America. And we're going to work together to do that. Coordinate, info share, train together, all those kinds of things. Well, this year, the Federal Trade Commission entered into a similar memorandum of understanding with the Department of Labor. And that was just entered into in August. So actually August 30th of this year, same thing saying, hey, let's work together to promote competition in our labor markets and to support welfare of our American workers. So the FTC, the U.S. Department of Labor, the NLRB, you can consider they're all working together at this point to try and help workers' rights, and that is going to have a significant effect on businesses and how they operate with restrictive covenants. Okay, speaking of the U.S. Department of Labor, it issued a proposed rule back in 2022, but we think it's likely the rule itself will be issued this year, probably in October. There was an extension of time for the rule to be entered, and it expires in October, so be on the lookout for that. But what it is the rule proposes a multi-factor test for whether or not a worker is considered an independent contractor. Of course, the default is always an employee. So it's only if you meet this multi-factor test that you do get to consider that worker an independent contractor. So keep an eye out for that. It's likely under this new multi-factor test that more workers will be classified as employees. And of course, the NLRB piggybacked on this with its own decision in June of this year. And it also announced a multi-factor test, which is very similar to the DOL's proposed rule. And what that test did is it overruled a test established during the Trump administration, bringing back, I think, a test from 2014. But again, it's a multi-factor test that employers should now be considering when assessing whether or not someone is an independent contractor or an employee, subject to a final rule being issued by the U.S. Department of Labor, maybe later this month. A couple other decisions of note here for the NLRB. Specifically, I want to call out this McLaren-McComb decision from earlier this year. And what this decision did was it prohibits employers from offering employees severance agreements, basically with restrictive terms in it, and specifically about non-disclosure terms or confidentiality. It was saying, hey, employees, you don't get a right to disclose the terms of this severance agreement, for example, and you don't get to require employees to keep all of this confidential. Also, with respect to non-disparagement agreements, they are generally only okay if the disparagement meets the definition of defamation. So that's something that's untrue. So it's allowing employees to say bad things about their former companies, and you can't put a blanket waiver on that. This McLaren-McComb decision was a big deal, and there was some kind of confusion about, hey, how do we enforce this? What do we do? So the NLRB Office of the General Counsel issued a memorandum following the decision in March of 2023, basically giving the opinion that, hey, these common provisions in severance agreements might violate that Section 7 of the NLRA. And not only is it these things that we've talked about, non-disclosure, confidentiality, non-disparagement, but also maybe non-competes and non-solicitation as well. So I think that's the opinion of the general counsel. This is broad. Anything that is chilling employees' rights and chilling employees' opportunities to talk about their employers and work conditions, any of those things should not be stopped. So this has had a big effect on many employers and the terms in their severance agreements or separation agreements. And, we've helped a number of employers through that. Happy to, talk through those things, of course, one-on-one, because they're pretty individually specific. But there are some changes that should be made probably to your separation agreements if you haven't done those already, to at least address some of this and make sure something you're putting in front of your employees is not, just explicitly violating some of these decisions we're seeing already. So keep that in mind. If you haven't paid attention to those agreements and the terms therein, you should take a look at those and consider how you want to handle changing them, or if you do. This is the U.S. Department of Labor issued another proposed change. And this is a proposed change to the overtime rules under the Fair Labor Standards Act. And what happened here is it's for the white collar exemption. So this is the executive, administrative, professional exemption that companies often have a number of workers that fit into that exemption. And there is a salary threshold component. Now, this doesn't affect the other components, the job duties test, things like that. So this is just about the salary component. But what it does is it really increases the salary to $1,059 a week, which is a little over $55,000 annually. And that is up from $684 a week, or about $35,000 annually. What this threshold would do essentially is extend overtime to an estimated 3.6 million more workers in the United States. So it would have a big impact. And most importantly, it would have a very big impact on employers, because people that you think of as being exempt, if their salary is below this threshold, they don't fit into that exemption anymore. And not only that, it would require automatic increases like every 3 years. So in the past, it's a static number. It did not keep pace with inflation or with the times. And so the proposed rule is trying to remedy that. You'll see here I put that there's a comment period for this. The comment period is still open. So if you or your business want to make a comment, you can do so. Go to the website and you can make those comments up until November 7. So likely what will happen is there will be many, many comments. Those will be taken in consideration, and it will be some time before an actual rule is finalized. But again, something you need to keep an eye on. Okay, let's turn to the U.S. Supreme Court. The first U.S. Supreme Court decision I want to talk about is this 303 Creative LLC. Elena's decision came out on June 30th. And this is not an employment case in particular, but it does raise questions for employers. So I think it's important to note. In this case, there was basically a sole proprietor web designer, and she filed suit against Colorado's Anti-Discrimination Act, claiming, hey, you cannot force me to create websites for same-sex marriages when that is against my beliefs, and I should not be forced to do that under this Colorado law. Now, the U.S. Supreme Court said, yep, that act violates the designer's First Amendment rights. And a lot of times there is some tension between First Amendment rights and other rights. But in this case, the U.S. Supreme Court went on the side of the First Amendment rights. What's notable for employers is that what this could do is it could lead to more employees raising religious objections to certain projects or workplace policies in the future. So keep an eye out for that. Religion is one of these hot topics that just seems to keep growing in terms of discrimination or retaliation lawsuits. And so it's important to be on top of what the employees' religious rights afford them and how you need to handle those in the workplace. This second one, also another religious beliefs situation we've got with Groff v. DeJoy, Postmaster General. This decision also came out end of June. And in this case, the postal worker requested not to work on Sundays based on his religious beliefs. Now, you might be of, the time that, oh, geez, do postal workers work on Sundays? That didn't used to happen, but now they all do. And that's for various delivery services, Amazon, and the like. So yes, postal workers are required to work on Sundays in many cases. And What this case looked at was the employer's burden in proving the undue hardship. So essentially, do you have to accommodate when there's an undue hardship? Generally, if it's an undue hardship to the business, you don't have to accommodate, but this needs to be more than a de minimis cost. So it raised and increased the burden, basically established a whole new standard for establishing what is an undue burden for the employer when looking at these religious accommodation cases. It makes it harder for employers now because what it needs to establish, or employers need to establish, is that the requested accommodation causes substantial increased costs in relation to the conduct of the particular business. So it's not just for this employee or something like that. You have to look at the overall business here. Now, it's not clear yet what facts would meet this new test. That is to be decided in the future. So what you need to take away from this is when considering accommodation based on religious beliefs, you need to look at the undue hardship piece and recognize there is an increased burden, and you need to assess whether or not there's substantial increased cost to the entire business based on this accommodation request. I'm going to end on two acts that actually were enacted. So these aren't just proposed rules or proposed rule changes anymore, but two real things you need to know about at the federal level. The first is this PUMP Act, which is Providing Urgent Maternal Protections for Nursing Mothers Act. Became effective earlier this year and essentially just applies for expressing breast milk and allowing time and private location to do so, which should not be a bathroom, of course. And the time period for allowing this is up to a year after the child's birth. The breaks can be unpaid, but if the person still has to perform some duties during this time, then it must be paid. You can consider, if you have fewer than 50 employees, a possible hardship exception. But by and large, most employers should be following this. And there's also, of course, state level protection. So this is at the federal level, but there are states that have protections as well. Washington certainly is one of them. And in any case, when there are both state and federal laws that apply, you need to be looking at the most beneficial protections for the employee. Here, I would assume most Washington employers are doing this already, but it's very important to note this is now at a federal level. So to the extent you have a workforce that spans outside of Washington, this is a requirement for your workers or a benefit for your workers in all states now. Last is the Pregnant Workers Fairness Act. So this one just took effect in June of 2023, and it applies to all employers with 15 or more employees. This is similar to the ADA or the Americans with Disabilities Act, but it's really specific for pregnant workers and has more level of detail to it. And I think it's important for companies because addressing accommodations for pregnant workers, I think gives people a lot of trip ups or employers a lot of trip ups on what they can and can't do. And so hopefully this is a good reminder of things that you may already know under Washington law, but if not, you've got to be doing this for all your workers nationwide. So here's what this is. The act states that employers must provide reasonable accommodations for employees' known limitations arising from pregnancy, childbirth, and related medical conditions. So what is that? Oh, and I should say this is for public and private employers. Some examples of what these accommodations are things like, this should be obvious. Okay, an employee should be able to sit sometimes or drink water. Those, are, I think, known and employers have worked through in the past, but there are more than that. In fact, there's a list and the rulemaking is still in progress. And so things could change, but it can be things like closer access for parking, flexible hours, having size appropriate uniforms, additional rest and break times, allowing time for leave to recover from any of these conditions. It can also include giving your employees exemptions from certain strenuous activities or even exposure to hazardous substances. So there's a long list. These are just the start. I think this will expand. And so you should keep an eye on that, but be aware that you need to consider all of these things. Now, of course, the exception is if providing these reasonable accommodations is an undue hardship on the company. This is a high standard. So in general, you should be providing accommodations. And if you can't, you better be prepared to say why this is an undue hardship on your business, and that needs to be a significant burden for your business. I think this is really important to note here is that what this act also does is it prohibits employers from requiring employees to accept accommodations without going through the interactive process. It prohibits employers from requiring employees to take paid or unpaid leave if another reasonable accommodation is available. So sometimes I think what trips up employers is that they say, oh, well, we'll just give you time off. Well, you can't require a pregnant worker to take time off without considering other reasonable accommodations that are available. So keep that one in mind. And of course, you can't deny qualified pregnant workers from various employment opportunities, retaliate against them, discriminate against them in any regard under this act. So please do keep that in mind for future. Oh, last thing on this, I think is important to note as well. Medical documentation. This isn't one of those where you just get to get medical documentation, if they want to drink more water. You can only request medical documentation from your employees seeking accommodation under this act if seeking this documentation is reasonable under the circumstances. So that concludes where we are at in the world of federal law. It has been a wild ride this past year. And what I can say is that for the upcoming year, you should expect much of the same.